Why do I need an electrician in my house? I don't want to electrocute myself. You don't want to spend money on an electrician, but you want to be safe at the same time. Why does everybody need estate planning? More than anything else, it's for predictability. Everybody wants to have predictability on what occurs when they pass away, since they're no longer in control. That goes for all ages, races, and nationalities.
We'll go ahead and get started to respect everybody's time that is in here. And we will try to keep this to under an hour. Don was on with us last year doing a similar one of these webinars, talking about estate planning, wills, trusts, all the fun stuff that everybody needs to prepare for. So Don, thank you again for coming on yet again and talking to everybody about this.
You're very welcome.
Don is the head of Henderson Law Group. He handles a lot of estate planning for our clients. He also handles a lot of, obviously, estate planning and business planning for a number of people that are not our clients. The idea for today is we are going to cover as much of this as possible. There is a lot that we're going to go through. About half of it is for individuals and families. The other half will be for business owners, as that has been something we've been getting a lot of questions on from the last webinar. Is we didn't really talk much about business owners. So we are going to get a little bit into that this time. For housekeeping purposes, and for any SEC representatives or compliance people that watch this, this is for educational purposes only. I know that I have a number of clients on here. Don has some clients on here as well. For the purposes of this video and this webinar, we are not your advisors right now, okay? This is purely for educational purposes only. Please do not take anything that we say and go and run with it. Please speak with a professional before you try to implement anything that we're talking about. So, with that said, we're going to try to touch on 7 different points today. We're looking at why estate planning is essential for everyone. This is a question I get all the time. We're going to go through some of the biggest mistakes that people make in retirement or in their estate planning. We're going to look at some of the key documents, what each one of them is, what they do, who they're for. We're going to talk about how you can avoid probate and reduce estate taxes if necessary. And then we're going to, like I said, dig into the business owner side of things and talk about some estate planning for business owners, why it's a little bit different. Talk about succession planning and exit planning for those business owners. And then lastly, we're going to talk about how they can sell their business and what that looks like for estate planning considerations. And then obviously we'll close it out, as we always do, with the live question and answers. So feel free to ask questions as we go. If it seems like a natural stopping point that we can go ahead and answer your question, we'll do it right then and there. If we don't get to it immediately, we will come back to it at the end. So feel free in either the question and answer box or the chat box, ask any questions that you've got as they come to mind, and we will address them at some point in time. So, Don, here's where I'm going to start handing everything off to you. I'm going to start kicking out some questions, as we always do. These are questions that I know that your clients ask you a lot. These are questions that we get asked a lot. And they're questions that we had people send in to us prior to this webinar to make sure that we can get some of this answered. And so that we can hopefully clarify, some of the craziness that is estate planning.
Okay, let's do it. So,
a lot of people tend to think that estate planning is only for the kind of uber wealthy, if you will. We've got 20, 30, $40 million. They need to do estate planning to save on estate taxes. So there's a 2-part question for you is, why is it that most people think that, or why do you think most people think that? And then part 2 is that accurate? I mean, do people with $100,000 in savings or $500,000 in savings or very simple financial lives, do they need estate planning?
I think the answer to part 1 is, why do I need an electrician in my house? I don't want to electrocute myself. You don't want to spend money on an electrician, but you want to be safe at the same time. And why does everybody need estate planning? More than anything else, it's for predictability. everybody wants to have predictability on what occurs when they pass away, since they're no longer in control. That goes for all ages, races, and nationalities. I can give you a good example of a client I'm currently helping try to clear title to real property. He's a grandpa currently in his 80s. His parents passed away a long time ago, but his parents didn't have wills. He doesn't have a will. None of his siblings had wills. Some of his siblings have passed away. And so trying to get this property sold is being a significant challenge because there's so many hoops and hurdles to jump through for the title company. So even if you just have one teeny tiny piece of real estate somewhere that's you don't think is worth anything, the time and expense to fix oversight is real.
So it's not necessarily that you're doing estate planning for yourself, because most likely, by the time that this is in use, you aren't around anyway. But you're doing it for your beneficiaries, for your loved ones, for whoever you're passing on anything to, so that they don't waste time and money trying to get it all situated.
I try to think of it as you want to make as easy a transition as possible without hoops and hurdles and costs.
Okay. So what happens if somebody doesn't have an estate plan in your case? I mean, who decides who gets the assets?
Okay. Well, if you don't have a will, your state, particularly us in Texas, they have default rules on who gets separate property, who gets community property, and things of that nature. If you're in a blended family where you're on a second marriage and you have kids from a previous marriage, I can tell you what the default rules are probably not what you actually want to happen. So passing away without a will leads to that unexpected outcome for your assets. It leads to additional costs. If you have to go to the probate court, instead of just having one lawyer, now the probate court appoints their own lawyer to make sure everything's being done the correct way. And then if there's a dispute between whoever your beneficiaries are, the numbers of lawyers multiply and the value of your estate goes down as a result, unfortunately.
Wait, so you're telling me if you die without the proper estate plan in place, you're leaving it up to your state government to decide what your best wishes are?
Correct. And that's generally, in my practice, a good way to get men to do wills is that you tell them if they pass away without a will that the court's going to appoint an attorney. Instead of paying one attorney, they're going to have to pay two attorneys.
So that's kind of where it comes into, you set up a will or an estate plan and it may cost you $1,000, $2,000, $3,000, whatever the price is for it. But if you don't do that, all of those prices that it could have cost you are now going to double for whoever you're passing on.
Correct. In Houston and Harris County, they just recently raised some court-appointed attorney rates. Mm-hmm. So at a minimum, the court-appointed attorney is going to get $750 from your probate estate, if not more, if something more complex happens.
Okay. So save your family $750 plus their own attorney that they have to get to handle the probate, correct?
Correct.
Okay. And then as far as time, that kind of discusses the money side of it, but as far as time, how long, give me a range on the short end and the long end. How long do these probates tend to go before the beneficiaries have access to the assets or everything's all said and done?
Yeah. Under the hypothetical where you have to go to the courthouse to get access to the assets, when someone passes away, you're not filing a probate application the next day. There's grieving. There's some type of grieving period involved normally. So you have that, we'll call it a delay. Once you do file your will, there's a mandatory waiting period before you can have a hearing. So that's another delay. So, and when the courts are busy, you might be, the worst case I've had is 8 weeks to get a hearing.
Just to get the hearing.
Just to get a hearing all the hearing is going to be is 5 minutes. And it's taken 8 weeks to get there from when you filed the application. Now, in certain courts in different parts of the state, it's only taken a week or 2 weeks once your waiting period's passed to get a hearing. But, 8 weeks or 4 weeks or maybe even 2 weeks, depending upon whether or not your surviving spouse or your children still have access to sufficient funds for burial or things of that nature, it could be a significant stressor.
So what, we hear sometimes about these horror stories where people, a husband passes or a parent passes, and let's use a husband and wife example as a horror story that I've heard, and I'm not firsthand. I don't know how accurate it is. That's why I want to bring it up and see from your point of view. Is you have a husband and wife, one of them passes, and let's say all the money, we'll use the husband because they typically die first, was all the money was in his name and his checking accounts, just had his name on it. They weren't joint. He didn't do all the proper setup to have a payable on death. And all the money's wrapped up in his name. No will, no estate plan, nothing done. Now, I've heard the horror stories that in that kind of scenario, look, the wife is still alive. She still has bills to pay. She still needs to pay the mortgage or whatever it may be. But she now doesn't have access to any of the accounts until the courts decide to give her access to it.
Well, once the banks find out that their account holder has passed away, they're not going to want any transactions to occur in those accounts because they want to the bank is liable to make sure that money goes to the correct party. And if there's no payable on death or transfer on death, or there's no surviving joint account holder, it's a question of from the bank's perspective, who are these rightful beneficiaries? And I need a court order, so to speak, in order to pay this money out.
So hypothetically, that in that scenario, the wife will be mourning when her husband passes. She may not know that she doesn't have access to it right away because she's always had access to it. And she gets her first, water bill, electric bill, whatever it may be, and she goes to try to pay it, and it doesn't get paid. That kind of initiates her to go ahead and file with the courts to start the whole probate process. And then you're saying it could take up to 8 weeks for you to even get that court appearance. So now you're looking at probably a 10-week period in this hypothetical where she doesn't have access to any money, no bills are getting paid, nothing's getting done. I mean, is that realistic? I mean, that's the kind of horror stories that I've heard. That's why I'm asking.
If the bank if someone notifies the bank, or if the bank somehow finds out that, a social security number in the death index, the bank notices it, it's something that could potentially happen. Okay. It doesn't happen in every case, sure. But it's a potential worst case scenario.
Okay. And I mean, and I bring that up because I know that in my world of what we do is, yes, it might be a long shot for something like that to happen, but you always want to plan for the worst case scenario and hope for the best. So that's why I just kind of want to bring that up so people can see that, it could have some serious effects on your loved ones if everything isn't set up properly. Obviously, I think the biggest mistake that anybody can make is not having any plan at all. But another kind of big one is that you and I have talked about before is beneficiaries and being outdated or incorrect based off your current life. How often do you see that, and how does that affect people?
It occurs occasionally. A good example would be something along the lines of maybe it's a surviving spouse situation. One child lives locally and all the other children live out of state. And the local child gets added to the checking account to, if there's a need to help. Well, when mom or dad or whoever the surviving spouse is passes away, that local child is now the joint account holder. The bank's going to want to pay them the entirety of the funds in that account. So it could cause potential issues between siblings if something like that were to arise.
So where the parents probably wanted everything split equally amongst the kids, but the local child gets put on there just to help with paying bills and stuff like that as the parent gets older. That one that's been helping is now going to get everything because his name is a joint owner.
For that particular account, the bank is going to want to pay the surviving joint account holder. And in this case, it'd be the local child. That's probably something very common that happens.
So how does that get worked out? I mean, if there's a substantial amount of assets in that account, how does that get worked out between the siblings that, hey, my name was on the account, all the money's mine, and the other kids are like, well, in the will, he said everything was supposed to be split evenly. How do they end up splitting that money, or can they?
Well, they can definitely split it. There's nothing stopping them from splitting it if the children are all, good relationships and raised correctly. But greed is a powerful motivator.
Well, now, how would that look from a perspective of, hey, all this money's mine, and now I need to split it with my siblings? Would that not be considered me gifting them this money at that point?
You could do a family settlement agreement to ensure that the split occurs, and that's what the intentions of the parent were.
Okay, so you can get paperwork done ahead of time, so it's not considered gifting. Gotcha. Well, the more you know. A lot of people think that and we've even had a couple people on here that sent in their answers to the questions we ask when they register, of they have a will and nothing else. What other basic necessities do you think are needed for an estate plan other than just a will? Because that's the one that everybody knows the best.
Okay, yeah. My basic estate planning package has a simple will, a financial power of attorney, it's often referred to as a durable power of attorney, a medical power of attorney, a HIPAA authorization form, which is your medical information form, and then a directive to physicians, which is your end-of-life decision-making form that essentially says if you have some terminal condition you're diagnosed with, you want either A or B to happen to you. Those are kind of the core documents. The thing to keep in mind for the financial power of attorney, it could be immediately effective if you want it to, or it could be delayed. The effectiveness could be delayed if you suffer a future incapacity event. Okay. The medical power of attorney and the directive to physicians, so long as you have the mental capacities to make decisions for yourself, those documents are not going to apply. It's only when you lose the mental capacity, like you go in and you're under anesthesia for a surgery, whoever your medical power of attorney person is, they're in charge of the decisions during that period of time.
And I think that's one hesitancy that I've seen a lot of people have is, I'm not dead yet. I don't want to give up control of my finances. I don't want to give up control of my medical decisions. I don't want to give up control of all these things in my life. But what you're saying is you don't necessarily have to. You're setting these things up for the eventuality that maybe you can't make these decisions on your own anymore.
Correct. So for the financial power of attorney in particular, you can have it immediately effective or it can be delayed. As long as you have your own capacities as far as healthcare, you can make your own decisions for healthcare decisions. The other benefit that all the financial and the medical power of attorney and these other documents provide is if something serious happens and you have to have a quote unquote guardian, these documents help keep you out of the guardianship space, which is very expensive, time consuming, and the court is in your business down to every single penny.
Okay. And so you're not giving up anything necessarily right off the bat. You're just preparing for down the road.
Correct. And you could also execute the documents, keep them private, but let the people know that if something ever does happen to you, these are the locations of the documents. Okay.
And that's something that probably should be said for all essential documents in your life, estate planning, financial planning. I mean, basically all essential documents is, we always tell our clients is keep all that together. We hand our clients a binder that they can put everything in. Some people want to do it digitally. Some people want both, but keep it all together and at least have a couple of people in your life that know where it is. They don't need to know what's in there. They just need to know where it is.
There's a question that's come in that's applicable if you want to answer it now, since we're talking about powers of attorney.
Spouse with Alzheimer's. Okay, so the question was, we have a spouse with Alzheimer's. When does the other spouse invoke the durable power of attorney? So I think this is kind of a two-part question: is when can they invoke the power of attorney, or when can you start to create a power of attorney? Like, is there a point at which it's too late to create a power of attorney?
So yes, there is. Once you don't have the mental capacities to understand the requirements to execute the document, there's a point where you can if there's a point where you legally can no longer execute it. If you do it anyway, it would be subject to challenge in the future. As far as utilizing the power of attorney, you're going to have to read the document to see if it's immediately effective or if there's a delayed effectiveness for an incapacity. And if there is a delayed effectiveness for an incapacity, the document should say what you have to do in order to prove that incapacity. So right, and it typically involves a doctor going to either the person's doctor or a specialist that can say there's a standard form to fill out that shows the person either has capacity or doesn't have capacity, or there's some capacity that exists, but other areas they don't have it.
So neither spouse is making the decision on if they're cognitively aware of what's going on or if they're capable of making decisions. You have to go to a specialist or a doctor that will test them and verify whether they have this ability or not.
Typically, that's the way I have my financial power of attorneys read, is that it says what the conditions are for an incapacity.
Have you ever seen or heard of a power of attorney that just says, hey, when you think that they're, unable to make these decisions, what are some other options?
Sorry to talk over you. The standard state form has basic language in it that says what's up and what's down. And you just have to determine if you have the standard fill in the blank state form or if it's a document prepared by a lawyer that has slight modifications to their form based upon their past practices. Okay.
So, Doris, I hope that helped with that question. And then the next kind of, I guess, error or mistake that some people make is just setting everything up in a basic will, maybe getting all these other powers of attorney and directives in place, but they don't actually have a true plan for maybe like estate taxes and working with a CPA or, a CPA and estate planning attorney working together to figure out the best course of action for all of their assets so that they're not having to give away a bunch of this to the IRS and it is all going to their loved ones. So, what type what should people be looking out for or be trying to do when it comes to the tax planning side of things with estate planning?
Well, right now, what people need to be looking out for is come January 1st of 2026, the exemption amount per person is going to be drastically reduced from what we currently have. Our current number is basically almost $14 million per person. Come January 1, we're estimating that number to be maybe 7, maybe 6. Nobody quite has a firm grasp of what the number is going to be. And that's for people with money, that's a quite drastic change in what's exempt from taxation. So it's important to keep your eyes in the news cycle to see if Trump and Congress do anything within the next 6 to 8 months to take care of this issue or to help resolve it or bring further clarity to it.
And that number can be changed with every president, right? Anytime they change tax laws, they can change that number as well.
The last 20 years have been a lot of changes to what the exemption number is, and we're just at a point where it's that point in the legislative cycle where it's going to be changing again.
Yeah. And so my question, when it comes to estate planning, you're sitting there, saying, oh, I've got $500,000 or I've got $1 million, but I still have a lifespan of probably 20, 25 years. That number is going to change quite a bit. If you've got proper financial planning, those accounts should be growing quite a bit over that time period. So is it, would you say it's behoove of people to start setting it up now for the anticipation that their total assets could be over that exemption amount? Or would you just say set it up for what it is now and then make adjustments as you go?
It's fact dependent. There are, for assets where you have a good expectation for exponential growth, it's something to seriously think about. But otherwise, we generally say, at a minimum, get an estate plan in place now. But in major life events or major economic events, make sure those plans are still accurate and good for what's changed in the world.
Okay, so I mean, because hypothetically, that exemption amount could go back to where it used to be $1 million, right? I mean,
they could eliminate it altogether.
Okay,
yeah.
So it's important to not just get an estate plan in place that worries about the tax planning now, but probably every 4 years or every time that there's a president that wants to change that number. If they change the exemption amount, go ahead and go get a review on your estate plan to make sure that it still fits with the current tax planning and estate planning exemption amounts.
Yeah. The Republicans have talked a long time about getting rid of the estate tax, and this is probably their best opportunity to do so in quite a bit.
Okay. And so updating the plan, when we talk about updating it for tax reasons, but I mean, there's other reasons to update your plan. How often would you say, or how important would you say it is to get those plans updated?
Less so updated, more so reviewed every 4 or 5 years, just to make sure that everything still needs to be the same. If something needs to be updated, if it's relatively minor, you might be able to not make any changes. But if something significant happens or there's been a family change in family dynamics, it's probably important to go ahead and dot your I's and cross your T's.
Okay. And then we just had another question come in, and actually this is a perfect segue into our next section. Robin asked, is it better to put all your assets into a trust? And if so, what kind? Mm-hmm. The next section that we wanted to talk about was actually the difference between a will and a trust. What kind of wills or what kind of trusts are out there, what the purpose of each one of them is. And we're not going to ask Don to go through all of them because there's so many that do so many different things. But if you would, could you just generally describe the difference between a will and a trust?
Right. So the thing that I generally say is there's what we call probate assets and non-probate assets. Probate assets are things that are controlled by the court, and non-probate assets are things that are controlled by some type of contract. So the easiest example of a non-probate asset is a life insurance policy. You pay to have a policy. There's a named beneficiary when you pass away. That beneficiary gets a check outside of the court system. A good example for a probate asset is real estate. If you own real estate in your individual name, it's subject to the terms of your will, and it's got to go through the estate planning process. So a trust is a good tool to turn probate assets into non-probate assets, thereby circumventing the probate process and the logistical delays we discussed earlier. As far as trusts are concerned, there's generally revocable and irrevocable trusts. For a good chunk of people, a revocable trust will get the job done. If for estates that are not subject to taxation, they'll generally you'll be able to check all the boxes that the client has. Irrevocable trusts, you can do some things to prepare for potential estate planning taxes. And they too, like a revocable trust, are all the assets inside of them are non-probate and not subject to the court system. So that's probably the biggest thing to keep in mind when you're trying to make a plan is what assets are controlled by your will and what assets are controlled by, like a payable on death statement for your IRA. That asset's a non-probate asset and passing outside the court process.
And so when you set up a trust, who's in charge of that trust and making sure, because obviously you pass away, there's a trust sitting there. Who's in charge of making sure that all your wishes are what actually happens?
Yeah. So for revocable trusts, generally you are the trustee during your life. When you pass away, presumably your spouse or a child, depending upon your family circumstances, is this what we call the successor trustee. So it's generally people that are in your immediate family. When you're dealing with irrevocable trusts and we're trying to do some estate tax planning, the question of who is the trustee is a little bit more complicated. Mm-hmm. But as far as most people are concerned, revocable trust, you're the trustee during your life, and your spouse or your children or a brother or other sibling, close family friend is the trustee moving forward if there's a need for the trust to continue.
Okay. And then, sorry to kind of backtrack here, but to go back to your probatable assets and non-probatable assets, mm-hmm. typically what you're going to want to put in a trust, if anything, is what? Your checking accounts, your
Right.
brokerage accounts, your house.
So, yeah, I think there's basically two approaches to utilizing a revocable trust. Either you set it up and you transfer everything into it, so to speak, or you have it set up so everything transfers into it at the time of your death.
Okay.
It's personal preference for your fact situation and what the client's trying to achieve.
And what's the difference between revocable and irrevocable? I mean, I know what the difference between the words, but what do the different trusts mean?
Yeah, so a revocable trust means you can get rid of it, make changes to it freely during the course of your life. An irrevocable trust, there's going to be one, you're not able to terminate it except for very specific conditions, and your ability to amend it or make changes to the beneficiary could be limited based upon what type of irrevocable trust you're dealing with.
Okay. So, Robin, I think all of that is a long answer for your question, which is it better to put all assets into a trust? And if so, what kind? I think that really is dependent on what you're trying to do, what your goals are. Is that a fair statement, Don?
Yeah, a lot of times people come into the office and they have a clear objective of avoiding the probate process, and they know they need a trust to do that. Sometimes, depending upon the types of assets a person has, we can make recommendations to do certain things with beneficiary designations or transfer on death deeds to achieve the same result without having the expense of a trust, but it's asset and client specific.
Okay. So it is possible to get everything done that she may be looking to do without a trust by just having the proper beneficiaries, transfer on death deeds, all that kind of stuff in place of the trust.
Correct. You just have to go asset by asset to make sure what you want to happen is going to happen and the paperwork for it's filled out.
Okay. And then we just got another question from Doris, kind of going back to the cognitive abilities of the spouse. In the community property states like Texas, if you have a spouse that's cognitively impaired, can you leave them as your beneficiary, or do you have to leave them? Because I know that a lot of situations where like an IRA, for example, is that the beneficiary on the IRA, if you're married, does have to be your spouse unless they sign off saying that they're okay with it being somebody else. So if they are cognitively impaired, does that still apply?
You're probably going to, it's much more complicated, but you're probably going to get into the special needs trust side of estate planning. And that's something you need to talk to somebody with on a fact-specific scenario.
Okay, so that's one of the things that I hate always telling people, but it's the nature of what we do. Is that is a dependent answer. It's dependent on your specific situation.
The bottom line is, as far as a will is concerned, you have to understand that your spouse has a 50% interest in the community property, so you can only give away your 50% interest and your separate property. So you can't give away your spouse's interest in the community property. You can only give away your own.
Okay. And then when it comes, kind of going back forward to where we were, sorry for bouncing back and forth here, but when it comes to those non-probate and probate assets, and you're looking at the estate plan for tax planning purposes, are those, do they do anything different for tax planning?
No, for taxes, they're all basically your gross estate. The IRS views what is your gross estate, and they either fit in that definition or they don't, so to speak.
So putting assets into a irrevocable trust or revocable trust, neither one of those is going to remove those assets from your gross estate?
No.
That looks like a very no, but maybe.
Well, there's a lot of specific rules with regarding irrevocable trusts. So it's important to have someone, if you're going to use an irrevocable trust to try to decrease your gross estate for estate tax purposes, it's important to have someone who's experienced in doing that, because there's a lot of nuances like we talked on earlier, who can serve as the trustee. If the wrong person is listed as the trustee, you may not have that asset excluded for estate tax purposes. So
So irrevocable trust can remove it from your gross estate,
Correct.
but you just have to follow very specific rules.
Right. The IRS has a lot of rules for different aspects of irrevocable trust that you need to follow.
Okay. And so when you're looking at your assets, when we keep saying the word assets, this is all your money, this is all your jewelry, your cars, your houses, your land. I mean, this is everything that you own, correct? Mm-hmm. And then how do, I don't know, like this is a question I tend to get a lot is, how do liabilities work when it comes to estate planning? Like if, a parent passes away, they don't have their spouse is already gone. They've got one child. The child inherits everything from their parent, but that parent had a very large credit card debt or something. Like, how does that affect the child?
Well, if you're going through the probate process where you're having to probate a will, if the credit card's in American Express is highly likely going to file a claim into your estate, and that's going to have to be dealt with. So if you're opening a probate estate, you're opening up the possibility for creditors to file claims. Generally, a good drafted will say, pay my creditors and my final expenses before my beneficiaries, but that's part of the song and dance of going through the probate process is trying to defeat creditor claims.
So if you can avoid the probate process by setting up your estate plan properly, you may be able to avoid some of those creditor claims.
You'll have a better defense.
Okay. Yeah. That was kind of a one-off. That wasn't even something I planned on talking about, but it kind of popped in my head as a question I get all the time. Now, when you're looking at the estate and the assets and you're a business owner, so how does that change things if you own a business? And keep in mind, like we talked about last month with Rachel, the CPA, when we're talking as a business owner, it doesn't mean you own Google or Apple or some ginormous company. This could be a sole proprietorship. This could be a little LLC that you set up to sell trinkets. A business is a business. So how does owning something like that, owning a business, differ from personal estate tax planning or personal estate planning?
So the first thing that you need to consider is, how is the business owned? Or do you own it individually and you're a sole proprietor? Do you own it in an LLC or an Inc.? What the circumstances are depend. When you pass away, it's going to dictate the outcome. If you're a sole proprietor and your business bank account is in a checking account under your name and the bank finds out you've passed away, payroll's not going to get made if you have payroll to make, because the bank's not going to want to let that account be used anymore. So it's a question of, can we still make payroll? Who's going to make day-to-day decisions? Are there other officers or other employees that are signers or on the bank account to where the company can keep using those accounts once you've passed away? Those are all important things to think about.
So you're a sole owner of a business. You don't have any true succession plans set up. You are married. You pass away. I mean, does the business automatically, like other assets, get passed to your wife or spouse, I guess I should say? Or how does that work?
Right. So in Texas, there's two opinions. One, there's a small group of attorneys who think you can designate your successor owner in the business in the company documents. I am not in that camp. The only way to pass along your business ownership is either through the will, or maybe the business is owned by your revocable trust. That's the only way to get your business to whoever your beneficiary is going to be. So one of those items is going to have to be taken care of.
Okay, so it's kind of like your assets. If you don't want somebody else to decide where your business goes when you die, then you need to make sure to set up an estate plan, whether in a will or set up a succession plan within the business.
Correct.
And you do a lot of work with business owners as well, both for estate planning as well for their business side of things. So what does succession planning look like? What should a business owner do to have a successful succession plan?
I think it's good for a business to be, with some employees, to be owned by a revocable trust. That way you're avoiding the probate process and the question of who's making decisions. It's not a question. It's already dictated by the trust. So there's a seamless continuity in order to continue to operate the business with the use of a trust. It helps to consider maybe you have an in-house accountant or a comptroller, some similar position. Maybe they're one of the authorized parties on the company bank account to make sure that checks are still cut and bills paid. That's something for you to think about, whether or not those individuals are trustworthy enough to do that.
Okay. And then, when it comes to like the kind of the example I gave earlier, where you own a business, there's no real succession plan set up, but you don't want the business going to your wife. Your wife doesn't want the business. She doesn't know anything about it, doesn't care to own it. Mm-hmm. Is there a way of setting it up so that when you pass away, maybe it becomes an employee-owned business, or it passes off to somebody, your right-hand person in the business, and they buy out your wife? Sure. Without them having to come up with a whole bunch of assets? I mean, because depending on the size of your business, your right-hand person may not be able to afford to buy the business if it's worth a lot. So right. How does that work, that passing of the torch? Right.
You kind of have to decide, are you going to start gifting away pieces of the business during your life? Or are you going to wait for someone to inherit it and let your estate planning documents do the work? Or are you going to create a sale condition to either a family member or a third party or someone that works there? Mm-hmm. As far as a sale is concerned, whatever deal you can work out is perfectly allowable so long as it's an arm's length transaction. If you're selling it to a family member, if it's not an arm's length transaction, the IRS is going to decide that a certain portion, there's a portion of value there that was gifted. So it's important to make sure that you think through things, who the right person would be. And even if the right person may not want it. So you may have some thinking to do on who's going to inherit this business or buy the business.
Okay. And in that scenario, you sell your business, or your wife, I guess, technically sells your business because you're not alive anymore. How does that work for the estate taxes or the taxes on the sale of the business? I mean, is she now... I keep saying she, just because I'm talking as if it's your business, Don.
I can answer the question. I know where you're headed.
So it's like it's if she sells the business, is she now liable for capital gains, and all of that money is also in the estate tax?
If it's owned, okay. So one, yes, capital gains taxes are at issue. Long-term capital gains taxes. In a situation where the business is left to the spouse in a will, and it's a community property asset, she's going to get a 50% step up in her tax basis on that asset to the fair market value of the asset at the time of death. So if whatever the business would have generated in capital gains taxes during the husband's life, those are reduced due to the wife receiving a tax basis step up on half of it at the husband's death. So you have one, you do have the long-term capital gains tax issue for sales. And then two, if the business is valuable enough to where it pushes you over your gross estate valuations, you could have estate tax issues without any planning done.
So potentially she could end up paying capital gains tax and estate tax on the same set of money for selling the asset.
I mean, yeah, the possibility exists, and that's in the specific hypothetical that you provided. The possibility exists.
Now, what are the most common kind of succession plans that I see to, I guess, avoid a lot of this or some of this is buy-sell agreements. Can you explain what exactly that is?
Right. So, in an LLC, you might have a members agreement, or in a corporation, you might have a shareholders agreement. And these documents might say a bunch of different things. If someone receives a third-party offer for their share, or if the company needs to issue new equity to raise money, or if one of the owners dies or becomes disabled or gets divorced, or maybe the community property spouse dies. All these different types of scenarios that could happen to an owner may trigger a right for either the company or the other owners to buy that equity to try to limit the number of owners in the company so that there's not an unexpected third party that suddenly becomes an owner in the business. Buy-sell agreements could also work for when maybe you're 50-50 with somebody in a business and you've reached the point where you just disagree on how the business is run and the business can't make decisions anymore. Maybe there's a clause in your documents that say after a certain period of time, if no decision is made, one party can offer to buy out the other party. And if that other party doesn't accept the buyout, then they have to buy out the other party. So it forces the documents are trying to force a resolution to these issues that could occur.
And do you see a lot of times that those buy-sell agreements are funded, if you will, for lack of a better term, with some sort of business life insurance?
Key man insurance, yeah. Okay. That's pretty common.
How does that
work? The company has a life insurance policy on the owner that's involved in the business, so to speak. And the company documents say that once he passes away, the company or the other owners have a right to buy him out. So the company has funds through the life and key man policy to follow through on its ability to exercise that now deceased active owner's interest in the company. It's providing, so the mechanism may exist for the buyout, but there may not be funding for it. And the key man life insurance is solving the funding aspect of the equation.
So going back to my example earlier, where we have the business owner, passes away, your wife doesn't want anything to do with the business, or maybe legally can't. In your case, your wife's not an attorney. She can't take over your business.
Yeah, my business is done. Yeah.
So either your business is done, or if you have a partner or something like that down the road, the key man insurance would allow that partner to buy the business from your wife.
And allow the surviving spouse to get that value from the business that the husband had in the business while he was alive.
Okay.
Yeah.
Perfect. And then, when you're looking at minimizing taxes on the sale of this business, we talked a little bit about the capital gains tax. What are some strategies or some ideas that people can use to reduce the taxes they pay on the sale of their business?
Right. So one of the things that you can think about is trying to, it's referred to as freeze the value of the asset. You do what we refer to as an installment sale to an irrevocable trust for whatever the business is worth. And so that business is, say it's worth $5 million. Now that $5 million business is outside of your estate for estate tax purposes. Mm-hmm. And if you're expecting it to grow exponentially, then you've saved yourself the trouble down the road from having to plan for a $20 million business in 10 years, whereas you've already taken care of it when it was small and less valuable. The installment sale allows you to realize taxes incrementally as far as capital gains taxes are concerned. So it's a pretty common tactic to achieve getting the business outside of your gross estate for estate tax purposes.
And so this may be a little selfish of a question, but I'm going to give my life as an example. And this may fit other people outside of my industry. I just don't know. So that's why I wanted to bring it up. Is, for example, my business, Assurance Wealth Management, has to be owned, due regulations, has to be owned by somebody who's licensed as a financial advisor.
Right.
Which means even a trust cannot own my business. So how do I go through of getting my business into a trust if the trust can't technically own the business because the trust is, between me and my wife, and she can't own it if she's not licensed. So how does that work if you're in a situation to where you really can't put it into a trust? Is there other ways of doing it?
Right. For lawyers, for veterinarians, for people in your industry, it's a lot more difficult because unlicensed individuals can't own the business. Mm-hmm. So it's helpful to try to get it taken care of during your life, to either have a succession plan in place or to have the documents in place to derive the value from the business. But there's no easy answer for any of those industries, especially when you're out on your own.
So you would say it's more important. I mean, it's important for every business owner, but it's probably even more important to have some sort of estate and succession plan set up for, attorneys, doctors, dentists, all these licensed practitioners.
Right. You need to have an understanding of what your state board allows.
And so you've now sold your business. Whether it's, let's say that you sell your business, obviously, while you're still alive. How do you go about preparing for retirement after that sale? I mean, what do you recommend as far as, does your complete estate plan change now that you don't have a business in it? Do you need to get new documents? I mean, how does that work if everything, your estate plan was revolved around your business, and then before you pass away, you decide, I'm going to go ahead and sell the business. Mm-hmm. So now do I need to update everything, or what does that situation look like?
Right. Depending upon the wording of everything, it's likely that you may need to do some updates. Selling your business might make things a little bit cleaner and easier, depending upon what you reinvest that in. Hopefully it's for lots of money and you don't ever have to work again. But if the possibility exists that you might have to work again, you have to take in consideration non-competition covenants and non-solicitation covenants in those deal documents to make sure that you're not going to accidentally breach your sale documents and now you're liable for something.
Okay. And then, we talked about a lot about the individuals and families. We talked a lot about the business owners and how they handle everything. But overall, it doesn't matter who it is, individuals or business owners or families or whatever, from an overall perspective, when you're looking at estate planning or business planning, how important is it to you, or how often do you feel the need that you need to work with that person's financial advisor, their CPA? I mean, is it just something that they can just go to, an estate planning attorney like yourself and just be like, okay, I'm all set, I'm good to go? Or do you think it's more beneficial for people to get involved, their tax professional, their finance professional, all together?
It's certainly helpful. Generally speaking, when you have a financial advisor in the picture, they've already caused the client to make some type of list or schedule or database of what they have and what the value of that is. Mm-hmm. And that's extremely a valuable resource for an estate planning attorney to have that right off the bat. So from a financial planner perspective, that's something I always appreciate. For tax plan, for your CPA, if you do have a business, what type of tax treatment your business has, whether it's partnership, pass through, S Corp, C Corp, one of those things, that's going to potentially influence what your estate plan is going to be. So understanding the difference between having an LLC and then having an LLC that's taxed as an S Corp for tax purposes, having the CPA involved and helping explain those nuances to the client is beneficial as well.
Okay. So you would think, we typically tell our clients that, working with kind of those three people, I think, tend to have the most impact on your estate plan, your retirement plan, and your taxes, is having them all work together. Because let's face it, when you're talking to a financial advisor, their goal is to grow your money. Now, not always are they doing it in the most tax efficient way. So that's why working with the CPA will help you be a lot more tax efficient with that growth of the money. And then maybe the estate planning attorney says, hey, legally, this is how your business should be set up from a legal, liability standpoint. But then your CPA may say, yeah, but if you do that, you're going to open yourself up to all these taxes over here. So having those two work together to make sure that everything is set up properly to both be legal and tax efficient is all very important. And so, personal opinion here I'll throw out is that I think it's very important for, if anybody's going to work with any of the three, you work with all three, and they all need to be able and willing to communicate to get everything handled so it's as efficient as possible. Now, the caveat to that is, look, if you're very good in one of those areas, you're very good at financial planning on your own. You've done the research, you learn, you read, all that kind of stuff, and you can do financial planning on your own, then just get an estate planning attorney and a CPA to help you. Same thing if you're really good at taxes. unfortunately for my work, the only thing that actually you have to have is the estate planning attorney, because unless you're an attorney, you can't do that stuff for yourself. So
you can do it for yourself, but it may not contain the magic language that it needs to have to be effective.
Well, okay. Let me rephrase that. In my opinion, again, solely my opinion, you should not do it yourself, because that's just going to open yourself up to headaches and nightmares that could potentially come along down the road. I think that we went through a lot today. we went through a lot. I think we covered quite a bit. We're nearing the end of the time that we allotted for this. I want to thank you. Again, this is Don Henderson with Henderson Law Group. If anybody has any estate planning questions, reach out to him, go to his website, give him a call. You could also set up a time to call us. We will get you in touch with him. My name, again, is Jaimin Garabedian. I'm the owner of Assurance Wealth Management. We host these webinars every month on a different topic to try to bring specialists in that can answer your questions, that can clarify some of these topics for you. So that is it as far as our portion of presenting the material and the questions that we've had asked before this webinar and during the webinar. I'm now going to open it up for anybody that wants to stick around to Q&A. Please feel free to type in the chat or Q&A any questions that you may have, anything that we didn't cover. If it's something specific to you, it may be something we need to address offline, and we can reach out to you and do that. But again, thanks, Don, for coming on today. And if you've got a couple of minutes to stick around, we'll see if we got any other questions.
Sounds good.
All righty. Again, this is one of the questions I actually received that we didn't address before this webinar was, if somebody has a will set up, let me put it this way, if they don't have a will set up, but they've only got one person that they're going to pass everything on to, nothing real complicated. They've got, a retirement account, a brokerage account, and checking and a savings. So that's about it. But everything they want to go to their one child. Mm-hmm. Is a will or a trust necessary, or could they just set it up with beneficiaries and TODs?
Well, ideally, you would set it up with beneficiaries and TODs and have a will as a backstop, and in case something gets messed up. If not, you're in a situation where you're paying multiple attorneys to go through the probate process to sort it out. In Texas, it's easy enough to draft a will with the correct language to make it as easy as possible, so there's really not an excuse to do that.
Okay. Well, it doesn't look like we have any other questions or comments from anybody, so we're going to wrap it up right there. I want to thank everybody for coming. I also want to remind you that we'll be doing this again next month. Look out for anybody that registered for this one. You will get a email registration for the next one. And if anybody has any questions that they think of once we get done, feel free to shoot myself or Donnie an email or give us a call. We will be happy to answer any questions that you have. Oh, last minute question coming in. What criteria do you encourage your clients to consider when naming an agent for their financial or durable power of attorney and the medical power of attorney? What about co-agents of executors?
Okay. Things to think about are, for your financial or for the medical power of attorney, someone who might be good at one might not necessarily be good at the other. So there may be someone who's medically oriented in your family or very compassionate. That would be a good choice for the medical power of attorney, but maybe there's someone who is less sympathetic, more economics based, that would be better for your financial power of attorney. As far as co-agents or co-executors are concerned, as far as executors in a will, I generally recommend to try to pick one person and not co-people. Co-executors typically run into disagreements in a will, and that leads to fights and to cost. For powers of attorney, I think it's more common and generally, in my book, more okay, so to speak, to have maybe both your children as co-medical powers of attorney, things of that nature.
Perfect. Again, if anybody has any more questions after this, or you would like a review of something you've got, or you just want a complimentary consultation for those that are clients of ours and you haven't had one yet, let us know. I think Don will be happy to sit down with you and review anything that you've got, answer any questions that you got. If it's financial planning, retirement planning side of things, I will be happy to answer any questions and be a resource for you. But other than that, thank you guys again for coming. And Don, we'll do this again, I'm sure.
Thank you for having me.
Yes, sir. Have a good one. Bye, everybody.